So these are some frequently asked questions related to retroactive versus prospective legislation, generally in the state of California. The first is, what's the general rule for the application of a newly added or amended statute? In most instances, legislation applies prospectively, meaning after the law has been enacted and takes effect. What does a retroactive bill or retroactive statutory language look like or sound like? The following example I'll read is language from a bill that was intended to apply retroactively. It says, the requirement to provide COVID-19 supplemental paid sick leave as set forth in this section shall take effect 10 days after the date of enactment of the section, at which time the requirements shall apply retroactively to January 1, 2021. What does legislative intent language regarding retroactive application look like or sound like? The following is an example I'll read of language where the legislature states its intent that a court apply the statute retroactively. It says, it is the intent of the legislature that a court interpret this section as amended by the act adding this subdivision in a manner consistent with the interpretation of this section as it read prior to January 1, 2013. Does the legislature attempt to make a bill entirely prospective? Yes. The following is an example of language that a bill is not intended to apply retroactively. It says the amendments to this section made by Senate Bill 284 of the 2021-22 regular session shall not apply retroactively to injuries occurring before January 1, 2022. Does the legislature attempt to make a bill retroactive and overturn a court decision? Yes, on occasion. The following is an example I'll read of language that a bill intended to have retroactive application and to overturn an earlier court's decision. The provision says, notwithstanding any other provision of this division, any injunction or judgment in effect as of the effective date of this subdivision, suspending or otherwise affecting enrollment shall be unenforceable. What does the legislature generally do to address prospective versus retroactive application of legislation? The legislature either states the operative date of statutory language or the legislature expresses its intent about when the statutory language is supposed to apply. And finally, are the state's courts required to follow legislative statements? The courts go through a process by which they determine whether the statutory language will or will not be applied retroactively in certain specified circumstances.